Hey guys, I'm back. I had spoken in my last segment about contingency agreements prepared and given to the policyholder for them to handle the insurance claim, and how that's a third-degree felony to do it because it's an unauthorized practice of law, because if they were the public adjuster, they wouldn't be able to be the contractor. So this is obstructing government operations, section 38-123, unauthorized practice of law, because again, the Texas Insurance Code 4101, it relates to adjusters, 4102 relates to public adjusters, and you cannot, on either statute, you cannot be the person who builds it back. You can't benefit from the salvage of it. So you can have those licenses, you just can't act in both. You can't wear both hats. But what I said was, if you weren't the public adjuster and you are the contractor, and you say that you can do my job, then you're really, because you don't have my license, and even if you did, you're acting in a different capacity, that falls under the unauthorized practice of law, which is the third-degree felony. So section 38-123A says a person commits an offense if, with intent to obtain an economic benefit for himself or herself, the person, 1, contracts with any person to represent that person with regard to personal causes of action for property damage or personal injury. That's property damage, okay? Storm and damage to your roof. 2 is advises any person as to the person's rights and the advisability of making claims for personal injury or property damage. So I have to be careful under my public adjuster license that I don't give legal advice. I just happen to know a lot, and it's a weird fine line for me because I have a 33-year trial paralegal background. So it's easy for me to be informative because I know, versus me giving you legal advice. I know the difference, but I also know how things work, so it's easier for me to explain it. I just have to make sure that I'm just informing people and not telling them what to do, not actually giving them advice. So 3 is advises any person as to whether or not to accept an offered sum of money in settlement of claims for personal injury or property. So that would be a roofer saying, oh, insurance paid enough money, or insurance didn't pay enough money, and we're going to go supplement it. That is practicing law. 4, enters into any contract with another person to represent that person in personal injury or property damage matters on a contingent fee basis with an attempted assignment of a portion of the person's cause of action, which would be, if you're not a public adjuster, a licensed public adjuster, that's anybody else. So you can do it as your own insured. You're the person, you are the policyholder. You can do it on your own behalf, obviously. A public adjuster, a licensed public adjuster can do it because the statute 4102 allows it, but also an attorney can do it, and an attorney doesn't have to have a public adjuster's license because they trump everybody. They're the doctor over the nurse and the admin staff at a hospital. So 5 is enters into a contract with a third person that purports to grant the exclusive right to select or retain legal counsel to represent the individual in any legal proceeding. Now, this goes to Barratry for public adjusters. I know what Barratry is because ever since I became a paralegal in 1983 or whatever, I actually took classes to be one. I know what Barratry is, and a law firm cannot even get somebody that's outside of their office, even if they work at their office, they have to have the ability to sign that contract, but ask questions to an attorney, not a paralegal. I've had lawyers say, hey, they're coming to the conference room. Can you just go in there and answer their questions if they have any? And actually that's illegal. The attorney has to do it. So I would go in there, but once they had a question about the contract, even if I knew the answer, I had to get the attorney in there to answer it because that's a legal contract. So what is happening is public adjusters and case runners, they don't call themselves case runners, but they are getting law firms contract signed. That's Barratry. It's illegal. It's illegal for the law firm. It's illegal for the person doing it. And a lot of people just don't know, so they're kind of doing it accidentally, because if they knew or they were informed, they might not want to do it. And there's a firm here, I used to work with one of the named partners in Louisiana. They're being sued for Barratry right now because they paid a company $3,500 for advertisement, but in reality that company went, solicited, and had had their contract signed, and that's a big no-no. That's happened here in the Valley. It happened there. They're going to lose their license probably because Louisiana's bars going after them. Then they will come to Texas, and now there's Barratry. So that's a no-no. Only a law firm can get them signed. And as a public adjuster, your job, if you're going to tell them that you can't help them anymore, and that maybe their next step is a lawyer, you really have to have the lawyer explain all of that and gather their information. You can share your file if your client allows you to share it, but even invoking appraisal, or if your client tells you to invoke appraisal, you can do that. But even giving them advice on, I think you ought to invoke appraisal, which I'll tell you this, contractors, roofers, they do it all the time. That's illegal. That's practicing law. Public adjusters, you do that. That's practicing law, because there are things called extra contractual. As a consumer, they have these other rights that by you invoking appraisal, that is a binding, like an arbitration type thing where they may lose out on other things, bad faith, or not paying under the Prompt Payment Act. Those are legal things that need an attorney to explain to them. So once you tell them, oh, invoke appraisal, or I'll invoke appraisal on your behalf, you're practicing law. I know people disagree with me. I don't care. I've had Renee Ziegman tell people in the Texas Association of Public Insurance Adjusting, the TAPIA meeting, and I can't tell you how many men who thought they were lawyers, who were public adjusters or whomever, said, no, we can do that, with a lawyer sitting up there telling them you cannot do it. It's unauthorized practice of law. They don't care because, they're smarter than everybody else. But anyway, then B on this section 38-123, this section does not apply to a person currently licensed to practice law in the state or another state or a foreign country, or in good standing with the State Bar of Texas and the State Bar or licensing authority or of any or all other states or foreign countries where licensed, and then also except as provided in subsection D, which is the next one I will read you. An offense under section A of this section is a class A misdemeanor, but the State Bar sees it as potentially a class 3 felony. So I always say it's a class B misdemeanor to be doing this, but it can be a class 3 felony. An offense under the subsection A of this section is a felony of the 3rd degree if it is shown on the trial of the offense. So State Bar of Texas would bring an action against you. They would charge you criminally because they're the entity. And then they would say if you've previously been convicted, maybe you got a class A misdemeanor before, maybe you got a slap on your wrist saying don't do it, and you did it again, they're going to come after you. If they find out that you've done this statewide, and maybe you've heard my thing or you just know this, Texas Department of Insurance is coming after you, or insurance companies have turned you in, that can be a 3rd degree felony. Now, I shouldn't say this, but a lot of contractors, roofers, the reason they like this is because they could have a criminal record. They could have a felony. It could be something stupid, small. It could be a DWI, third DWI that's a felony, whatever. And so they're on probation. They can't be having this happen to them. And potentially a class A misdemeanor might, if you're on probation, might just flag you for something else and get you in trouble if you're doing some other things that are kind of nefarious or right there on the line. Your probation officer could come after you. But it just, be educated on this. That's all I'm saying. But again, this is section 38-123, unauthorized practice of law, and it's under the obstructing government operations under the penal code. So this is the penal code, right? This is the criminal code. Anyway, stay safe, be prepared.